let me introduce our next panel. The panel relates to issues of data, technology, and privacy, and it will discuss trends in class action litigation arising out of data breaches and related data privacy claims. And I have the privilege of introducing the moderator of the panel, Amy Worley, who is one of my colleagues at Berkeley Research Group. Amy has almost 20 years of experience helping companies across industries build and implement programs that unlock and protect the power of information as a competitive advantage. Ms. Worley practiced law for 16 years before moving into industry, and she advises clients on regulatory compliance with laws, including HIPAA. Ms. Worley also litigated and tried several cases related to loss or theft of competitively sensitive information. And immediately prior to joining BRG, Amy was the Global Chief Privacy and Records Officer for a multinational specialty pharmaceutical and medical device company. So thank you, Amy, for joining us today.
Thanks, Jeff.
Next, I would like to introduce Karen Hanson Riebel. And Karen concentrates her practice in the areas of data, antitrust, and securities litigation. She has litigated a number of complex class actions and has represented numerous pension funds and other institutional investors involving corporate fraud. Recently, Karen has been on the forefront of international data breach litigation, representing financial institutions against such retailers as Target and Home Depot. Karen began her career by spending 7 months in Anchorage, Alaska, as a member of the trial team that secured a jury verdict for punitive damages in the amount of $5 billion in the Exxon Valdez case. And lastly, I would like to introduce John Yanchunis. And my apologies, John, if I mispronounced your last name. John, the class action department of his firm, and his practice is concentrated on complex litigation spanning a number of decades, and nearly 2/3 of that time has been specifically with respect to class actions. John has served as lead, co-lead, or class counsel in a number of class actions spanning a wide variety of areas, such as affecting consumers, including antitrust, civil rights, defective products, environmental claims, and life insurance. During his career, John has tried numerous cases in state and federal courts, including one of the largest and longest running insurance coverage cases in United States history, which was filed in 1991 by the Celotex Corporation. So with those introductions in hand, let me turn it over to our panelists to get started. Thank you so much for being participate today.
Thank you. So hi, everyone. Welcome to our panel. The last question that Brian answered, I think, teed us up pretty well for our discussion today. We're going to focus a lot on class action cases, specifically in data breach, in privacy, and trends now that we are really just starting to live in the world with the CCPA. And I was actually looking at my IAPP, International Association of Privacy Professionals listserv before getting on here. We have new federal privacy legislation proposed last week. We have new federal privacy legislation proposed all the time. But I think that these are interesting times, dynamic times to talk about, how do we in a class action context deal with these somewhat unusual disputes and injuries. So actually, John, I was going to go to you first and sort of set the groundwork for when we talk about a data breach class action, what type of claims are typically included in those? I know Brian talked a little bit about statutory versus common law. Are there typical class action data breach complaints, or are we still figuring out what those look like?
So I think, as Brian mentioned, there is reliance upon common law concepts grounded in the 18th century and even before, or 19th century, excuse me. And there's been an emergence regarding the use of consumer practices statutes, Deceptive Trade Practice Act. I had a case some years ago where Judge Ursula Ungaro recognized that in a data breach case, she could apply one of the three prongs, if not all the prongs: unfair, deceptive, and unconscionable in connection with the data breach. There's certainly been some state laws that have emerged, California being probably at the forefront and having the most robust law in the country. As I think you mentioned, there's an absence of federal legislation, but in connection with what we've been dealing with, kind of the marrying of older 19th or 20th century laws to 21st century technology, we're doing fine. And I predict that as people, legislatures appreciate more and more the need to protect privacy, how companies monetize our personal information for their own gain, you're going to see an expansion of state legislation. I'm not sure what's going to happen on the federal level.
So Karen, I was interested because I think John's 19th century point is a good one. When I teach these issues, I usually tell people that the law is, when it's being very fast, it's 10 years behind the technology. This sort of seems like maybe we're a century and a half behind the technology. How do we go about proving claims under, common law right to privacy, or the, most of us, I think, are familiar with the famous law review article about what is privacy. How do we litigate current technologies under really old legal standards?
Well, that's a great question. And I guess my experience has been that once you get inside and start taking discovery of these companies that have had really big data breaches, you find that there are unbelievable holes in the data security systems in place. And so I would say that it's not as hard to apply the common law theories of, say, negligence, even negligence per se. Challenges are more causation and damages. And I know that's on our agenda to talk about, but I think that's the tougher row. Problems that we're going to see, I think, in legislation, whether, the state schemes and proposed federal, which I can't imagine when we'll ever see a federal statutory scheme actually go through, is that they're very specific, and the state statutory, like the Illinois HIPAA and the California scheme, and New York has one. Minnesota, where I am, has the Plastic Cards Act, which deals with retailers and banks, but is still pretty substantial credit card data privacy and protection legislation. But it's not enough. Those are never enough. You always have to add common law claims, and I don't think that applying common law to modern technology is the problem. And I don't think there is a problem, to be honest. But I don't think that's where the real hurdles are. It can be, of course, and sometimes you have standing issues, and those are talked about all the time, and everybody, I'm sure, is aware of those. But I don't think that's the real tension, frankly.
So, Amy, Karen and I are co-leads with Norm Siegel in a case against Capital One. And on Friday, the judge entered an order which kind of looks at and takes a tort that I really like, the breach of confidence. It was a tort recognized in the Godiva chocolate case, albeit that decision is been vacated while his petition en banc is being considered by the 11th. But Judge Trenga found that claim as a viable cause of action in our amended complaint. So congratulations to Karen.
And to you, John.
Absolutely. That's fantastic. So one of the, and I will say, in my role right now with BRG, my team and I serve as an outsourced data protection officer for several multinational companies. And one of the things that we've seen is an increase in ransomware. And I think people know about ransomware, but I don't want to assume. And so what it is a form of malware that infects the network or a unique device, and it encrypts the data on the device. Now, I always talk about good encryption and bad encryption. Good encryption is the one you have the keys to. Bad encryption is the one that the bad guys have the keys to. And it used to be the case that this would happen and your data would sort of be held hostage. Now we're seeing more of it where your data is held hostage and they steal it and may publish some of it on the dark web or threaten to publish it. Either of you who wants to take a shot at it, but I'm wondering, are you seeing an increase in ransomware cases? And how are those being handled in terms of, is locking the data a breach, or is it something else, some other bad thing?
I'm sorry, Amy, I just didn't quite hear what you said. Is whatting the data?
Locking it down. So it's
locking it down.
If we were doing it under European law versus US law,
Right.
The availability breach, which exists in European law and is maybe in New York, but kind of still a fuzzy notion in the US.
Yeah. Well, I'll take a jump in, and then John, please, of course, add. I mean, I think that you're seeing that increasingly, and it's always about safeguarding data. And there are ways. I mean, this is an interesting conversation, frankly, because as I like to say, if you're not concerned, you're not paying attention. And I mean that from every single one of us who is part of a law firm, assuming that most people on the phone are lawyers, or whatever company you work for, you are vulnerable to and responsible for the protection of your data. And I think it's really that simple. And so I think even in the case of ransomware, the entity that takes the data from the consumer has the responsibility to lock it down. So we see elements of ransomware in many of the data breach cases that we see.
So I had a opportunity to file a ransomware case. I think it was the first one in the United States. The first case, as I understand it, filed in the world was in Belarus. It involved a company called Allscripts, which handled information for medical practitioners. And for, I think, approximately 8 days, doctors were unable to get into patient records, scheduling, and any number of things that they place in the hands of a company handling their electronic information. That case, unfortunately, was not successful because there was an arbitration provision and the judge did not find a claim against the parent where there was none. But I consider a ransomware to be at least a security incident. It's how you want to define the legal term of data breach. If a company has had their information security system breached, there is at least one type of relief that I believe a consumer has a remedy for, and that is injunctive relief. If a company does not have the ability of maintaining the security of their information the first time, they shouldn't be given a second chance without having judicial oversight. So Karen and I were in the Facebook case before Judge Alsop, not a ransomware case, it was a data breach. But the fact remains is that we were able to advocate that once a company loses its information, there should be judicial oversight and better cybersecurity measures enforced by a judgment. There's this saying we have in the South that if a fox gets into the chicken house, you don't ask the fox how many chickens it ate, you count the feathers. And so true, I believe that to be an effective silver bullet in any data breach case, even in the absence of any kind of financial repercussions, because why should we then wait for this to occur again? Ransomware is affecting law firms. There have been some celebrated cases where lawyers decided not to pay it, and then they had their information placed on the dark web, or their clients' information. So I believe it to be an emerging problem. Companies are paying, and cities, counties are paying ransom. And as long as there's a way for cyber criminals to make a dollar, they're going to continue to go back and try to make the dollar the same way. So it's a huge problem, I think, in this country.
So the other thing I would add to that, I don't think I heard you guys say it, but the Department of Health and Human Services actually has guidance on ransomware too. So under HIPAA, they consider ransomware affecting PHI to be a breach that is reportable. And it's, you know, John, it's exactly what you're saying. Particularly if you're a physician and you are relying on accurate and up-to-date electronic health records, those not being available can have very real harm to an individual who has a medical allergy or a pre-existing condition that a physician would need to be aware of. I launched a poll just a second ago to see how many folks are experiencing this. I'm going to give people a little bit more time, but I think the results are sort of interesting. On the topic of ransomware, there are, as I understand it, kind of two ways to get into a system and lock it down. One is through, a brute force attack. You get past the firewalls, you get into the hen house, you're the fox and you're in there. The other is with phishing. And I have some opinions about how companies are dealing with phishing. But I'm wondering, have you guys dealt with it much in the context of lawsuits? I could see a company saying, gosh, this phishing is very convincing, it's very good, it really did look like an email from the IRS, or it really did look like a memo from the CEO of the corporation. We didn't do anything wrong. Any reasonable human would have clicked on this link. Thoughts about that? How are you handling that?
Well, I haven't dealt with any law firms lawsuits. I haven't had a suit like that. Maybe John has, and he can tell us about it. But I will say that we are constantly training the people at our law firm to deal with that, because it happens all the time. And again, I actually think that the issue of privacy and cybersecurity is bigger than just class action lawsuits. And I know that's not our panel topic, but I just always sort of feel obligated to say it again. If you're not worried about this in your personal life or your professional life, please start worrying, because you are under attack at all times, whether you know it or not. So I'll let John answer if he's had a lawsuit like that.
Actually had quite a few, and those are pretty easy for me. I'll give you an illustration. So a school district here in Florida had a phishing email delivered to somebody in HR, allegedly from the superintendent of schools, who said, could you send me all the W-2 information of all of our employees? Over 4,000. Now, what would you think would be the reasonable response? Pick up the phone and say, Ms. So-and-so, by the way, why do you need all that information? That did not happen. All that information went out to the superintendent of schools, not her, but someone else. I probably had maybe a dozen of these cases. I've never had to push them very far. They've gone to settlement pretty quickly, because there is no excuse for engaging in that kind of activity. And in large part, they've all been to people in HR, and in every single instance, all the W-2 information of every employee was sent to a malicious actor.
Wow. So let me see, I'm working, sorry, trying to get a poll up. Nope, that's the poll we already did. All right, I'll try that in a second. One of the ways that I advise clients to deal with this issue of phishing, and I think that we're probably getting to the point where it's just a reasonable expectation for security professionals, it's multi-factor authentication. So my own experience, both in a law firm and as in-house counsel, I had clients complain loudly and vigorously over the arduous task of having to, tap their cell phone to get into the network. They just couldn't stand the second ask. In my experience, multi-factor authentication almost always defeats phishing because it will send you a ping back. Hey, Amy, somebody in Poland is trying to access your O365 account. Are you cool with that? And I get the second opportunity not to mess up and say, oh, no. I'm not okay with that. Wondering, in terms of pleading these cases and proving these cases, I would think multi-factor authentication would be a ripe topic for discovery. Have you guys gotten into that, and is this reasonable security?
Well, that's a good question. I mean, that's of course something that would always come up as a defense. If and that would be we'd be notified of it in security, and I'm sorry, in discovery. We'd find it in discovery. But usually what you're dealing with is a breach where there's an inside bad actor and outside bad actor, more than ransomware, at least in my experience. But since John's done much more ransom types of cases than I have, I probably should just let him start talking. So sorry, John.
So, I think multi-factor authentication is a way to effectively, particularly when it involves a transition of information or money, is a necessity. And again, in every case I've handled, that did not occur. One of the things that all companies should be doing is to have education to ensure employees understand that if they get a malicious phish, that they check it out. They make certain that it's from their intended person. We have a program in my law firm, a series of modules that we routinely have to take. If you don't take them, after a while, your computer shuts down and you're locked out. We also have an active phishing campaign, and if you click on a phish, an email you think is proper and it's not, then you're locked out of your computer, and you go through an education to ensure that you understand how poorly you responded in that regard. So I've not yet found companies that I've sued that engage in that activity. And I'm sure, like everyone in the audience, nobody likes to spend money on privacy or privacy protection until.
Oh, don't tell people that.
But it's true.
Well,
we find that true all the time. You find that all the time in discovery, that there's corporate culture of ignoring data security, which is just shocking every time, but it happens just really every time. Nobody wants to spend money on it. But John described as something that we do at our firm also, and I think it's so important. And it is everybody, from the person who's helping us by ordering supplies, all the way to the partners whose names are on the door. You do not want to be dinged on those phishing tests.
And we do it at BRG too. It's really important. Some of them are very, very good.
Yes.
I've definitely looked at them for more than a minute going, but it's always better. I mean, that's the thing. It's better to err on the side of not doing it. If somebody really needs to get in touch with you, I always say telephones still work.
Right.
It is still, you can still call somebody.
Yeah.
So we were talking, Brian was talking a little bit at the end of his last talk about injury. And how do we prove injury? And I know, John, you spoke about the aggravation and the headache, and I hate free credit monitoring as a remedy for lots of reasons. One, my credit is monitored to death, and two, I think that it has some downsides too. You know, ongoing credit monitoring can cause problems for consumers. But before we get to remedy, on the injury side, Karen, how are you thinking about proving up injury?
Well, I mean, as I think Professor Fitzpatrick talked about this, and that they're really, I don't think it's a clean split, but we're finding in different jurisdictions, different courts, that sometimes courts will find an injury sufficient to find Article 3 standing, and sometimes a court won't, and it feels to you like it's the same. We spend a lot of time working really carefully and diligently in pleading our complaint to make sure that we have plaintiffs who have injury and who can talk about what they've suffered in the wake of the breach and have documents. And I mean, I was very interested when Professor Fitzpatrick was talking about the challenges book that he thinks are good challenges. One of them was the issue of you can just plead anything, and then the defendant can't win on a motion to dismiss because plaintiffs have just pled anything they want to plead. And I don't think that's actually going on because of Rule 11 and just because we all are officers of the court, because these injuries are really real. I mean, there are people out there who are really suffering in the wake of these breaches with having all kinds of problems, from, you know, credit cards opened in their names to having to, we have a plaintiff who had a cell phone purchased in his name and had his own phone number transferred to another device. And so he was really lost for a long time without the use of his phone. So things like that. So I think we just, as John mentioned, we just had a really good ruling on injury and standing in the Capital One case out of the Eastern District of Virginia on Friday. And I think there's some very good holdings there on standing.
So I wanted to raise 2 points on that. One is, as a victim of a data breach a couple years ago, I came home from a vacation and had a call from a federal agency that regulates tobacco, firearms, those sorts of things. And they said, we were just inquiring about your large-scale purchase of weapons. And I said, really? I got some pepper spray. It turned out that my credit card had not just been stolen, it had been used to purchase a lot of weapons, which of course caused more injury than just dealing with the reversing out the charges on my credit card. I also had to have a lot of conversations about my firearm habits and what they might or might not be. So just throwing that out there anecdotally. And then in the spirit of sort of bipartisan political discussions, I do think it's interesting in the post-Cambridge Analytica era. What is the injury to someone whose data goes out in the world and could be used for things like hyper-targeted political advertising, or you know, could impact in some way or another potentially democratic process?
Well, John, why don't you, I think you've done more with that kind of injury than I have, but
Yeah,
I mean,
can I go back perhaps and lay a foundation by answering an observation you made, maybe one that Professor Fitzpatrick. It may well be that a lot of companies that have suffered a data breach have offered identity theft protection. A very small percentage of the American public have actually accepted it. So do not, 3%, that doesn't shock you. And you know, I've been in with Karen, not with Karen, many, many breaches, and I know what the claims rates have been. For whatever reason, people simply aren't accepting that benefit, and it is significant because it is a layer of protection. Is it the only thing people can do? No. One of the other things, you know, I think there needs to be recognition of is that time is a compensable element of our daily lives. It's the way in which most people are compensated. How much time we spend, whether it be a 40-hour work week or a lawyer who spends time to earn a hourly rate. And without question, in the wake of a data breach, companies and certainly government tell you what, to protect yourself. If people did not, you would have a defendant saying, you failed to mitigate your damages, you failed to take action to protect yourself. So it is natural for consumers to move forward to protect themselves. Another thing, and I think it touches upon the issue, is when information is taken, it's a violation of oneself, correct? We give this information to a particular company for a particular purpose. If it's taken, if you're unable to come up with a demonstrable amount, many states have, at common law, the concept of nominal damages. Here in Florida, we have nominal damages for both breach of contract as well as tort. And why is that? Because the law recognizes for every wrong there has to be a remedy, albeit nominal damages. And there are cases, if you dig into the literature, the case law, where juries have awarded substantial sums of money, albeit not large sums, but there's a case in Georgia, the amount for that nominal damage was $16,000. You multiply that by, say, the 97 million people that we have in Capital One, you're talking about some real money there. In connection with the way this information is taken, we can't always assume there's going to be a temporal injury, right? It's taken and it's used perhaps years from now. You have to be on guard for the rest of your life. Let's say your Social Security number is taken. Doesn't expire. Our mother's maiden name never changes. And this information could cause us to be forever on guard while we live. So the best way to address that is through identity theft protection. You may not, but it provides a layer of protection along with vigilance. And there's no question, there's no marketplace. There's this, certainly there's a dark web and you can see things put on the dark web, but not every criminal does that, right? Who monitors the dark web? Every law enforcement agency in the world. So the criminals have come up with better ways of ensuring that they go undetected when they take information. And you know, our time is precious. So you mentioned if it's taken and it's used for marketing purposes, well, we're having to spend time to deal with that. And again, time is a compensable concept in America. It's how our country, you know, pays people.
So we
You can tell I'm pretty passionate about this.
No, I love that. I agree with that. And I, you know, I could talk for hours about the sort of non-tangible, the non-economic violations that come from having your information disclosed without your consent. We did have a question. What was the name of the Capital One case on standing? I think we just called it Capital One, but the actual caption?
I'll find it.
Okay.
While she's looking, you know, I want people to think of privacy in a different way. It's an extension of oneself. You know, well over 100 years ago, we ended slavery in this country. The recognition that people should not own other people. It's an abhorrent concept. Our privacy belongs, right? We share that with companies or with friends based upon a particular need. But when that information is taken, it's a violation of our liberty, our individual rights. So that's part of what we're trying to do is to kind of push some of these concepts into the data breach world that are grounded in the United States Constitution and various amendments.
Have you ever brought any of these cases under state constitutional privacy rights?
I have, not successfully.
I have this now. So this just came down on Friday, and the case caption is NRA Capital One Consumer Data Breach. I'm sorry, NRA Capital One Consumer Data Security Breach Litigation. It's MDL number 119 MD 2915, and it just came on Friday.
Thank you.
Mm-hmm.
So I wanted to kind of pivot a little bit and talk specifically in terms of classes about some of the issues in getting a class certified in this type of litigation. I would imagine that commonality is the big issue to be litigated, but I could be wrong. So what are the issues that come up in trying to get your class certified in these cases?
Well, of course, you're right about commonality is a big one. You know, we're always looking at whether if the damages can be proven on a class-wide basis is a huge one that we look at too. John, of course, has maybe the second class certified in one of these cases in his Facebook case in California last year. Isn't that still right, John?
That's a Patel
Well,
versus
it's our case. Karen's in that case too. I don't know why you say it's my case.
You were lead counsel, John.
So Amy, it deals with obviously a data breach. We ended up, unfortunately, with only one plaintiff. The other ones fell by the wayside. And that plaintiff only had spent an hour and a half dealing with, I think, 3 phishing emails. It did move Judge Alsop. I think we had some greater degree of injury. I think we would have been able to certify a class under B3. Instead, we ended up with a class certified under B2 for injunctive relief with independent oversight. Karen and I and others settled that case. A motion for preliminary approval is pending before Judge Alsop, and I'm sure it would have been granted, but for COVID-19 having kind of slowed the system. But, you know, I believe there are some demonstrable that we can get around commonality and predominance. You know, I mentioned the nominal damages. I think that could be certified under B3. Risk of identity theft. Information is taken for one reason, and that's to cause injury, typically to monetize it to the injury of consumers, although it may have to be coupled together with other information available out in the atmosphere. And the way you respond to a risk of identity theft is with identity theft protection. We have many states in this country have concepts of medical monitoring, either as a cause of action, typically more of a remedy. It's a completely adaptable concept to how to combat risk of identity theft, and that's with identity theft protection. So I think you're going to start seeing some advancement of the concept of marrying that concept to a data breach, depending upon the type of information taken.
So I think it was Andrew Yang in his Democratic primary bid. I may have the wrong person, but who was putting forward the idea of an economic interest in your personal data.
Did you say that was Andrew Chang?
Yang, I believe.
Andrew Chang.
And there is some language in the CCPA that would indicate that you have an economic interest in your personal information. I'm wondering, has that argument been made that sort of, it's like a property right? You know, the information that I have about myself that I'm sharing, you, Facebook, you, Google, shouldn't be allowed to profit on with retargeted advertising without compensating me for that. Or at least without my express consent to do it without compensating me for that. Has that been tried in a litigation context yet?
It has. It gets tried a lot. Part of the problem is what often has happened at the pleading stage is again, this kind of proves the point of we don't just plead anything that we want to survive a motion to dismiss, because what sometimes happens is we fall down because the plaintiffs can't show that they have tried and failed to sell that data, because even though they will complain, of course, you've taken my personal data, you corporation, and now monetized it without my permission. If you can't show, that's not always the case, but it's often that, you can't show that you've ever tried to sell it. So does it really have value to you if it's not something that you would?
Interesting.
Certainly the California Consumer Privacy Act advances that concept.
Right.
And we settled a case last week under that act. It's not yet been papered. There's certainly arguments that were presented to us as to why it didn't apply, but in any event, it was the foundation for a component of the relief being provided to California residents.
And how is the CCPA changing how this type of litigation is? I know it's new. Part of it went into effect in January. The Attorney General was going to start enforcing it in July. We're on a 3.5 round of regulations, which is weird. Regulations from an Attorney General are unusual. But John, how are you seeing the CCPA play out in the litigation context?
Well, again, it's only been actionable since January 1st. I've had 3 cases under the Act, 1 now going through the settlement process, 2 remain active, and then I've got with some tremendous lawyers at Boyce Schiller and Sussman Godfrey, 2 cases against Google involving their privacy practices. So I think you're going to continue to see it applied to companies that certainly do business in the state of California in some regards. And hopefully we'll have it, more states will begin to adopt it. I had an opportunity to do some lobbying in my own particular state, and I used the biblical statement that it depends upon whose ox is being gored, and I didn't find a very friendly audience in this state subcommittee. But I had pretty much directed all of them the fact that every single one of the members of the Senate subcommittee had been the subject of a data breach. So at some point, they were going to feel the pain and realize they got to protect themselves as well as the consumer public. So I try to personalize that message, which you can't do before a jury, but I do it as much as I can with a judge.
Karen, how about you?
Well, I second or I echo what John said. I haven't personally hadn't done any cases under it or bringing it forth as a claim, but I was getting ready for today and just kind of looking at a roundup. And although it's brand new in January, there are tons of cases out there already. And I think we need a really heavily litigated, it's a great addition to the statutory scheme. I hope other states like Florida follow suit. Illinois, I call it BIPA, Biometric Privacy Act. There's a ton of litigation under that, and that I think went into effect in about 2005. Unfortunately, what we don't see is the data security competency rising with the lawsuits and statutory schemes that are available that are available in the wake of the breach, people who are injured by the breach. So is there going to be increased litigation? Absolutely. Will it increase corporate attention? I don't know.
What do you think is the gap there? Because it's, we work internationally. We're very heavily involved in GDPR preparedness. Recently working in Brazil on LGPD preparedness, and for those of you who don't know, the penalties for violating the GDPR can be 4% of global revenue, which most companies will pay attention to. I would think that the cost of dealing with data breach litigation, even if it's nominal damages, even if it's injunctive relief, would have a deterrent effect, but it sounds like your experience is no. Why do you think that is? What do you think we need to do to get there?
Well, that's a really good question. I'm not sure exactly why it is, other than I think there's an element to it of sort of corporations not wanting to spend on it, because that's then, and whose budget line is it under? How do we pay for this? Who's accountable for it? I also think, in fairness, that I think you started out by saying that the law is catching up to technology, but I think that also cybersecurity is behind the hackers always. There's always people who are one step ahead and able to do things. And what has to happen probably is more of those people need to be hired by corporate enterprises to run the data security departments.
Yeah, government intelligence has been doing that for years. They
Right.
Go arrest the hackers and then hire them.
It's odd, but everybody's behind. So I don't know if John shares that opinion, but.
No, I don't share the opinion. Probably the one area of disagreement. I think companies are capable of being in front of the hackers. I don't think some of them are. Obviously, I've taken enough software engineers that when I see a gap in their resume, I kind of figure out what they were doing during that gap, whether in prison or working for the government. I kid you not. So there is a disconnect. Obviously, I think there are a lot of companies on the face of the earth that now are their revenues based upon the use of information. It is what I've heard described as the new oil, the currency of the 21st century. And I think there is a tension between those in the tower that want to expand their profitability by using information, and those down in the basement want to do their best to ensure compliance with the law as well as to protect it. And I don't know that there is a company yet that I have found that has met that challenge. I might have a couple in mind, but I'm not going to say them because I'm sure those words get back to haunt me if I were to sue them with Karen at some future date. But we have, Karen and I have undertaken litigation against some of the biggest companies in America, and inevitably we have found, working together, that these companies do not maintain current technology, best practices, so to speak.
I did want to, we don't have a lot of time left, but I did want to circle back to, John, I think you mentioned earlier the UDEP claim, the unfair and deceptive trade practice claims. The FTC has its version of that claim that it brings against corporations, often because their public privacy notice is deceptive. It doesn't match what they are actually doing with consumer data. How often are private plaintiffs bringing those claims, and what's the level of success there?
We bring them all the time, and I think we have a great deal of success. I could probably name you a number of cases where courts have found, based upon what companies advertise as their privacy policies, to be not so, and then there is a deceptive element. But don't overlook the unfairness component, and perhaps even unconscionability, because unfairness deals with, I think, the collection of information and how you safeguard it. Consumers are given the belief, so sometimes expressly told, that their information will be maintained. But I think the failure to maintain best practices resulting in a breach is qualifies under the unfair component or prong of the UDAP statute.
Karen, you were nodding your head. Have you brought the UDAP claims for violations? I always think of them as sort of turning your own privacy policy into a mini statute. You've said this is what you're doing, so you need to be doing it.
Better do it, right? Well, yes, I have with John and a few others, and the case that we were talking about before, Capital One, very good language, and I think what John get, tell me if I'm wrong, Washington, Texas, California, New York, Florida. So I think, I mean, it's again what John and I were just both talking about, that there's sort of this disconnect in the corporate culture, if you will, of monetizing data, thinking let's get as much data as we can because this is great, we can monetize it, this is fantastic. And then you have people sort of at the lower end of the corporate hierarchy saying, okay, but if you get it, be really careful with it. That is the piece that isn't translating, even though the people in the marketing department over here understand that consumers now want you to talk about it and want to be sure that you're being careful with it. We're drafting privacy policies, putting privacy notices on web pages, and they're talking about it. So I really do think it is just very odd to connect.
So because I build these programs, I'm wondering how much discovery you guys do into the effectiveness of internal privacy programs. What procedures are established for marketing to be talking to the privacy team to make sure that, they're aligned? Is that an area that you're looking into? It's a fairly new thing in the US outside of the healthcare and finance space.
Right. Yes, I would say we cover it, but I don't, and again, John may disagree with me on this, but I haven't seen it as a huge area that we are drilling down into and spending a whole lot of time on. Do you disagree, John?
Amy, again, give me that one more time.
Sure. So, one of the things that we do is we go in and we build privacy programs and put internal procedures in place so that if marketing has a great new idea for using consumer data, that there's a compliance check, there's a control in place. And I'm wondering, that existed under HIPAA, it existed under GLIBA, it's new, basically from the CCPA and the GDPR. But are you starting to see discovery into that in your case?
Well, yeah, I mean, what I like about this area, aside from protecting consumer privacy, is getting into the company's privacy policies and that tension between those in marketing or the business side and those in the cyber side. I've spent most of my work in these cases trying to appreciate, understand, and determine whether there are inadequacies in that relationship. And inevitably, particularly in companies that use information to monetize it, there is a tremendous disconnect between those that try to protect it and comply with the law and those that try to monetize it. And why so? Because the privacy side doesn't make any money. They only spend money, and when there's a problem, it affects the bottom line, but it doesn't increase the revenue of the company. It's kind of like buying tires. Nobody likes to buy tires, but when their tires blow, they got to go get them. And really, that's the area that I like to look into the most.
So we have about 5 minutes left, and I wanted to be sure if anybody in the audience has questions, feel free to put them in the Q&A, and we can respond to those. And then while we're letting folks put those in, I do want to comment, John, on your last statement about privacy programs. In my experience, companies are starting to invest in these. And one way that can be helpful to get the investment going is to get them to understand that if they have a good privacy program in place, they actually can use their data more effectively. It's like a sports car with brakes versus a sports car without brakes. You know, a Ferrari can go really, really fast, but without brakes, it's not a very good idea. And we're talking to businesses all the time saying, if you build these programs out the right way, if you do culture awareness, get buy-in, teach people what the responsibilities are, then your race car's got brakes and you can go a lot faster. So any help evangelizing that message is is appreciated.
Amy, I hope to use that in a closing argument sometime before jury order case. I don't know that
analogy.
No, I happen to love that. I may not be able to give you credit for the concept, but in my heart, you always have that credit. It will come back.
Thank you so much. So, any last thoughts from you two, and then we'll toss it back over for the next topic.
I would just say again, even if you don't take away any litigation pointers from us, please pay attention to this at your law firms or your businesses, because it's dangerous, and in your homes too. And you know, there are real consequences to this, even despite a few holdings that there were there's no Article 3 standard because there's no damage. I disagree strongly, and it's getting worse and worse.
We've not even talked about the Internet of Things.
Right.
I've got a case against Ring right now with some other lawyers that Karen and I practice with from time to time. Very interesting case. And of course, there's the Zoom case before Judge Coe.
Judge Coe.
My kids hate me because we have a house without the Internet of Things. We don't have an Alexa. We don't do smart toys. And I actually have an air-gapped computer that I do all my finances on. So
I think that's wise.
Well, thank you both for joining us today. Thank you all very much for your attention, and we will pass it over for the rest of the conference.
Thanks, Amy, for getting us going and organizing everything. Appreciate it.
My pleasure.
Thank you, Amy. Bye-bye.
Bye-bye.
Well, John and Karen and Amy, thank you. Data privacy is a paramount issue in our personal and professional lives. You did a really good job with that subject. We could talk about it for much longer. Because cybersecurity is such a prevalent concern, we have a related ethics panel on Wednesday titled Protecting Data in Class Actions. So it's day 3 of our program at 12 Eastern. We hope everyone will join us for that panel too.